Welcome to Plan on It.
Welcome to Plan on It with attorney Christopher E. Botti, board certified specialist in estate planning, trust and probate law, and founder of Botti Morrison Estate Planning Attorneys. I'm Leanne Lyon, and today we are breaking down what long-term care estate planning really means, why it matters for California families, and how it protects both your assets and your independence. This is episode 2. What is long-term care estate planning and why is it important? Chris, when people hear estate planning, they often think of wills and trusts. How do you define long-term care estate planning and how is it different from traditional estate plans?
Well, great question. In my opinion, they shouldn't be different. But like traditional estate planning, not only from a client perspective, but for those who don't really do this on a regular basis, just involves preparing for death. Like I'm going to pass one day. I probably want to commit to writing what I want to see happen with my stuff when I die. And that's generally when people think about estate planning, they're thinking about dying and planning for death. But really, estate planning should also include planning for incapacity, right? If I get sick, if I cross the line and I can no longer manage my affairs financially or make medical decisions, I need to put in place a series of documents that will protect me in the event that happens. And statistically, there's about a 50% chance before someone passes on that you're going to cross a line and someone's going to need to step in and help you. And so when we talk about long-term care estate planning, what we're talking about is incorporating into your traditional estate plan provisions to deal with incapacity and providing in the estate plan, baking into the estate plan language that allows planning to occur down the road when you're ill and can't do it yourself, to potentially tap into some of the programs under the Medi-Cal umbrella. So long-term care estate planning should, in my opinion, be incorporated into every person's estate plan. And those who know what they're doing will do that. Like the attorneys that engage in this practice area that are elder law attorneys who are experienced and knowledgeable will always put in their documents language to allow this planning to occur. I call it long-term care compliance. I'm not sure if I'm the first one who coined that term or not, but I think it's a very appropriate term. Your documents must be able to deal with the changes in the future that could occur to your health. And you have to have the flexibility baked into those documents to allow someone to step into your shoes and plan on your behalf. So for all the clients out there who are listening to this, who are concerned, are my documents long-term care estate planning compliant? The answer is absolutely yes. I've never drafted an estate plan that did not include provisions that allows this planning to occur. Every document I've ever done in my entire career includes language to engage in long-term care estate planning. But I review a lot of trusts as part of my career, client interactions. Clients will come to me with trusts prepared by, non-attorneys, and there's lots of non-attorneys out there who create the impression they are, who prepare estate plans, and their documents are inadequate when it comes to these issues. And even attorneys that are not specialists, who are general practitioners, for example, they don't really realize the nuance of all this and the importance of having the documents being long-term care compliant. So in my opinion, again, going back to sum it up, estate planning should incorporate both, right? A true comprehensive integrated estate plan should be able to deal with death and incapacity and include provisions in there to deal with long-term care issues.
Yeah, so you mentioned earlier that oftentimes people don't really think of this, comprehensively, but what does usually prompt families to start thinking about the long-term care portion of this? Does it come from seeing a loved one enter a facility or from wanting to stay ahead of rising costs? What is it?
What we call that a triggering event, right? What prompts you to think about? Because you don't want to think about death and incapacity on a regular basis, because if you did, you'd have a mental illness, and that would not be helpful. Or healthful, I should say. Helpful and healthful. And so it's a triggering event, like either an illness to a friend or a family member or yourself. You learn that you applied for long-term care insurance and you were denied coverage for whatever reason, or the cost of long-term care insurance is so prohibitive that you can't afford it. Those are triggering events. Also, just learning about the Medicare program in general and how it really isn't designed to deal with long-term care, and it provides very little, if any, coverage for long-term care. Once you have a triggering event that usually prompts you to reach out to someone like me and say, what do I need to do to protect myself?
And you have mentioned, this isn't just financial, it's also legal, it's also medical. So, what documents form that foundation of a proper long term care estate plan in California?
Typically deploy revocable living trusts for people who are homeowners. And the reason why we use revocable living trusts as the foundation is because we don't want to go through probate, right? And we're going to have podcasts strictly devoted to that subject matter. But the revocable living trust is an amazing vehicle in that, done correctly, it will avoid probate. It will incorporate into it provisions that allow long-term care planning to occur on your behalf if you're incapacitated. And if you ultimately end up tapping into the Medi-Cal program, the state gave us a gift back in 2017. And it basically, the rule is if you don't have a probate estate, i.e. you have a living trust, then the state cannot recover against your assets. And that was a gift to planners like me. And all you got to do is set it up correctly and you're protected. So a comprehensive integrated estate plan for someone who owns a home would consist of a living trust, what they call a pour over will, which is a special will that works in conjunction with the trust. You have a financial power of attorney, and you have an advanced healthcare directive. That's the core 4 documents that would be part of a estate plan for someone who has a home that would have a probate estate. And those provisions, those documents would be integrated so that there's reciprocal provisions in both of them to allow this planning to occur. And for those of lesser means who don't necessarily have a probate estate, you're still going to want a will, and you're still going to want a financial power of attorney, and you're still going to want an advanced directive. And so those are the core documents that you need to do this planning.
So let's turn to talking a little more about Medi-Cal planning. Many people assume that it's only for low-income households. Why is that misunderstanding so common, and what do higher net families overlook?
Well, it's the myth of you can only have $2,000 in your name before you seek assistance under the Medi-Cal umbrella. That myth has been around forever. It has never been accurate whatsoever. And it's now going to be brought back into existence again as a result of the return of the asset test on January 1st of next year. And so it's never been true that you can only have $2,000 in your name before you seek assistance, because the state will classify assets as either exempt, which means they don't count towards eligibility regardless of their value, which means your home is protected, along with a bunch of other assets that I outlined in the ebook. And so it's not just for people who are destitute. If you only have $2,000 in your name, you're pretty much destitute. Okay. No, this is middle class. This is upper middle class. These are people that if they were forced to have to pay $15,000 a month or more to pay for a skilled nursing facility, they would burn through their cash so quickly they would ultimately end up having to go bankrupt. And that's the number one reason why seniors end up going bankrupt, is paying for long-term care. So the Medi-Cal program has never been designed strictly for indigent people. But the state, because they would prefer, and I can understand this, right? They would prefer that you spend your own money first and not know that there are things that can be done well before you reach the $2,000 limit. It can be done to qualify for these programs. And that's where the elder law attorneys come in. We come to the rescue basically and say, look, that's not the case. It's never been the case. And here's the deal. And so that's what really was the genesis for me to create that ebook I wrote years ago, is because, being an estate planning attorney, when I first started my practice, I was aware of these issues, but my clients were still relatively young. And so as they started to age and start encountering these issues, I started to interact with them and realize, hey, wait, they believe in that myth that there can only be $2,000 in their name, despite that the case that's never been true. And so that forced me to say, I need not only to educate my clients about this, but I also have to educate the general public, because I feel it's our mission to do so. And so that was the reason why I created that ebook in the first place, to kind of get out there. It's not just for indigent people. Never has been for just indigent people, the program itself.
That's good information. And I know also in your book, you point out that most estate plans actually fail Medi-Cal compliance tests. So what kind of provisions or omissions cause those plans to fall short?
Okay, so Medi-Cal planning can be viewed by some as rather aggressive planning, because basically what you're doing, if you have excess resources, in other words, you would fail the eligibility criteria, you would fail the asset test under the new rules that are basically a reversion to the old rules. But as of January 1st of next year, we have the asset test returning. And so if you have excess resources, you have to transfer those resources out of your name in order to qualify. And that those powers, the ability to gift or move assets, to take something that's community property and make it separate property, these are powers that have to be expressly put into the documents. In other words, your documents will not work for that purpose unless there's specific language allowing Medi-Cal planning to occur on your behalf, specific language that allows gifting to occur on your behalf in order to qualify for Medi-Cal, specific language that allows someone, if you can't do it yourself, to create an irrevocable trust or a trust on your behalf. And those provisions not only have to be in the trust itself, which but also have to be in the power of attorney. If they're not in both documents and they're not reciprocal and they're not integrated, then the only way someone can get the power to do this on your behalf is having to go to court. So now we're getting the courts involved, the probate court in particular, and you have to get some type of conservatorship proceeding going on your behalf, which is incredibly expensive and totally unnecessary. And so the key is having the documents with the express language. Without the express language, you cannot deploy those documents for that purpose. And that's the most important thing that people have to understand. When I talk about long-term care compliance, I'm talking about, does your power of attorney and your trust align together? Do both of those documents work together to allow someone to plan for you if you can plan for yourself? And without it, they will fail. And so all of my documents I've ever created my entire career contain the language I believe is critically necessary to do this planning.
Wow, that is a lot to balance. You're talking
It
about
is.
protecting assets, keeping access to care, families staying compliant, not losing control of their resources. How do you design these plans?
Well, the key is like when someone comes in for just general estate planning and like they're just coming in, I need an estate plan, I need a trust, I want to avoid probate. The conversation is going to eventually get to a point where we discuss incapacity and what could happen down the road. And so I educate all my clients and every one of the attorneys in my firm does the same thing. We talk about, okay, well, if you did get sick, you have to understand that there are programs available under the Medi-Cal umbrella that could provide relief. And we just try to plant that seed so they file that away in the back of their mind. They realize, okay, if something happens down the road, there's a solution. I should reach out to Chris and we'll find out what can be done. And so, it's part of the planning process. You have to have that conversation. Now, sometimes you get people that have an immediate need to tap into these programs. And then we just have to see, are your documents compliant? And I review a lot of documents to see, are your powers of attorney, do they contain the gifting language, the ability to create trust? And if you don't have that language, then you have to really deliver this really sad news to these people who thought they were protected and they weren't, that their documents fall short. And the only way for us to step in and help you is actually get the courts involved and get the probate court involved. And so that's really unfortunate when that happens. And so the key, again, is when you're planning just your general estate planning, just doing that, you should also be thinking about these issues.
I know in addition to your book, you hold workshops occasionally. Can you share an example of a family who benefited from planning early? And what changed for them once everything was in place?
I think again, the ultimate goal, at the end of the day, if you want to distill it down to its essence, estate planning is really all about peace of mind, right? Knowing that, hey, if I pass on, I'm able to say where my stuff goes in a way that doesn't have to get the courts involved, that it's going to be handled privately within my family. I planned for this and I have the documents in place, and that's peace of mind, right? And so during the workshops that I put on, the general estate planning workshops I do, I'm trying to hit home the importance of having these documents in place, hoping that you never need them, because if you need them, something bad has happened. But if you have them in place, then you're perfectly positioned for yourself and your family to tap into programs down the road if needed. So without the foundational documents, without what I call a comprehensive integrated estate plan that's Medi-Cal compliant, without that, you don't get that peace of mind. And so we deliver that peace of mind. So for all of our clients, they can rest assured, they can sleep at night knowing that they're protected, right? And so that's what we deliver. That's what we give to our clients, is putting them in a position to succeed on all aspects of this.
Oh, perfect. And oftentimes I know couples will come to these workshops as well. How does long-term care estate planning coordinate with the community property rules, the spousal protection laws that we touched on in our last episode?
Okay, so basically, the spousal protection laws are designed to protect the spouse who's at home. We call the well spouse, and so that they don't go bankrupt, right? Paying for long-term care if their spouse gets ill. And so when you do estate planning with couples and you have community property versus separate property, the key is Medi-Cal doesn't really care whether it's community property or separate property, but you must have power to manage both types of assets. In California, we have what they call community property and separate property. And so your power of attorney, your trust must give the well spouse the power to manage both the community property and the separate property of the ill spouse, so they can engage in all aspects of this planning if someone gets sick. And so the interplay is basically each spouse must cross-deputize each other and give them the power to manage all their property, whether it's separate or community. And if done correctly, it's a non-issue when it comes to tapping into these programs. And the spousal protection laws are designed so that our clients don't have to go bankrupt paying for this care. And that's a nice feature that California has embedded into the law.
Well, I think we've clearly established today how important it is to work with a qualified person in these cases. It's complex. There's multiple facets to all of it. So how can families who already have an estate plan find out whether it actually addresses long-term care costs and Medi-Cal eligibility, or if it's time for an update?
Well, I mean, if you have an existing estate plan and it was done by someone who knew what they were doing, then we're encouraging those people who are not our clients to go back to their attorney who drafted their estate plan and ask these difficult questions.
Right.
If something happens to me, are these documents sufficient enough so that someone can step into my shoes and seek these benefits on my behalf? A review should occur. Now, if that attorney is not capable of doing that review, if they've lost contact with their attorney, they don't have a relationship with anybody anymore, we'd be happy to review their existing documents to determine whether or not they are, what I consider long-term care compliant. So you can make an appointment with me or any of the other attorneys in my firm. We can review the existing documents that you have and tell you whether or not they should be fixed, because the time to fix them is now. You can't fix this paperwork when you need them, because if you've lost legal capacity, it's too late. And so the time to look at this is now. And unfortunately, with the rule changes that are going to happen that we alluded to and went into great detail in the previous episode, there's a narrow opportunity right now to engage in some planning. And so people should consider looking at their paperwork now and being prepared for the future, and going to someone like myself who's qualified to be able to give that assessment.
And that's a great lead into a final question for today. Earlier in this episode, you mentioned 4 things that need to be in place: revocable living trust, a pour-over will. You want to go through those 4 again, just briefly?
Yeah, I mean, there's actually a little bit more, but the core 4 of the documents, if you have a probate estate, which means you own a home in California, in my opinion, you should do a trust. The revocable living trust is the centerpiece. That does all the heavy lifting. It says where your stuff goes when you die. It also has provisions in there that allows for someone to step into your shoes and manage your assets in the trust on your behalf in the event of incapacity. And then you have a financial power of attorney, because that document is important to have, because not everything you own is going to be in the trust. It can't be in the trust. So the power of attorney allows, someone to step into your shoes and manage assets that are outside the trust. And so you need both a financial power of attorney and the revocable living trust, coupled with the pour over will and the medical power of attorney, which in California we call an advance directive. Back east, they're called living wills, but we call it an advance directive. So with those 4 documents put together correctly with integrated provisions, you're there. Okay. And that's for people with a probate estate. If you don't have a probate estate, you can get away with 3 documents. You don't need the trust. You still need a will and the power of attorney for finances, and of course the advance directive. They're all incredibly important.
Well, wonderful. Thank you for all this great information today. And that's it for today's episode of Plan on It with attorney Christopher Botti. To access more resources, including the 2026 Medi-Cal ebook and upcoming estate planning workshops, visit boddilaw.com. Thanks for listening, And don't forget to like, leave a review, and subscribe to the show so you never miss an episode. Thank you, Chris.
Thank you.
If you're enjoying Plan On It, be sure to subscribe, leave us a 5-star review, and like the post. Share or tag friends and family who could benefit from clear, practical estate planning guidance.